very last question now. Cohabitation or prenuptial agreements. You suggested kind of sitting down with your partner and discussing these while you're still like each other. Can you maybe give us some examples as to what are some of the issues or questions that partners should sit down and discuss?
Okay, and this is probably another good area where it makes sense to divide the discussion between if you're in a cohabitation relationship as opposed to you're going to get married or you've just recently gotten married. Usually you do that kind of agreement if it's in contemplation of marriage or like a prenuptial agreement. That's literally what prenuptial means, is before you get married.
Right.
Is that what you're doing is you're saying, okay, the Family Law Act and the Divorce Act set out basic things that are going to happen in the event that the relationship breaks down. There are certain things that are in the legislation that you can opt out of. So you can decide for yourself how you're going to deal with those issues in the event the relationship breaks down and you're going to separate. And again, this is something you said you found funny when we were talking about it earlier, is what I've always said is that it's a lot better for people to sit down and be actually forced to think their way through about who's going to be playing what roles during our marriage. How are we going to handle money in bank accounts? Is everything going into the same bank accounts? Are we each going to maintain our own separate bank accounts? What if one of you is coming into the marriage with a matrimonial home where you're going to be living together as husband and wife, and that person's owned the house for 20 years and there's a lot of equity in that house? Under the normal Family Law Act rules, that you have no entitlement to, like you have to do an equalization of that family property. It doesn't matter if you brought a matrimonial home into the marriage, but in a cohabitation or a prenuptial agreement, you can say, in the event we ever separate, I'm entitled to a credit for the equity I had in the house as of the day we got married. So you can deal with issues of spousal support in advance. You can deal with an equalization of property in advance in a prenuptial agreement. Family-owned corporations is quite often something, and that's probably the main reason why people do enter into marriage agreements, is because one of the parties is bringing in an asset that they own. They have substantial ownership interests in a family-run or small corporation or even a big corporation, and they can specifically set out in the agreement how that interest in the corporation is going to be dealt with in the event that the marriage breaks down in future. Is the other spouse going to be entitled to make a claim in that or not? Because it could impact the whole way that corporate, especially if it's a family-held corporation, like mom and dad and person and their sister own this company. Is it going to be part of your family property, your interest in that property? What happens if it increases in value during the marriage? Like you might say, again, treat it like you do the matrimonial home, that you get a credit for what it's worth on the date of marriage. But if your spouse is helping you and you're increasing the value of that, then you might agree that it'll be just any increases in the value are going to get shared. Actually, it's really quite funny because way back when I could have still been in law school or even articling or very, very early years of practice, I remember talking to a very experienced family law lawyer. He said, you know, what we should do is make it an awful lot harder for people to get married. But they cannot get married until they've gotten independent legal advice and they have signed a marriage contract.
Oh.
And it's only after they've gone through and done this whole process, provided complete financial disclosure, totally understand all their rights and obligations, both have had independent legal advice, and enter into a binding and formal prenuptial agreement. Then, and only then, can they get married. And we'll make the divorce really, really easy because they dealt with all the hard stuff when they really liked each other. So they were willing to be fair with each other when they're looking at embarking on married life. And so they're making all these decisions saying, geez, you know, if this relationship just doesn't work out, it's a lot better to try to figure out what should happen when you're willing to be fair to the other party when you still like each other, rather than doing it when you hate each other's guts and you don't want to do anything that would be considered fair or rational or reasonable. You're just mad. If you have entered into a marriage contract, it probably makes sense to review it at least every couple of years, just to see if it needs to be updated or changed or anything else while you're still getting along together. But if you don't do it and the situation falls apart and you separate, then if you entered into that agreement properly and it's a binding agreement, then it will govern. You can ask a court to set aside
Right.
prenuptial agreements, and that actually is done quite often, which again, we talked about, because you were just saying, like, is it just like once you've done it, you're stuck with it forever? There are ways, and there are cases in Canada where the prenuptial agreement or marriage contract have been set aside by the court. Quite often the scenario that you see where they get set aside more often than anything else is the bride is told 3 days before the wedding that she has to sign this agreement that her husband-to-be's lawyer just prepared so that she keeps her
Yeah.
paws off all this other property that he's bringing into the marriage. And it's, if you don't sign it, we're not getting married.
Yeah.
And you don't have time to get a lawyer, you've just got to sign it now.
Yeah.
So she signs the agreement, and then 15, 20 years later, the relationship breaks down and she goes to court to get the agreement set aside because she signed it under duress. That's not that unusual of a scenario. But then you can spend hundreds of thousands of dollars fighting about, well, really, was it under duress? Did the parties have independent legal advice? Should the agreement be set aside?
Exactly, because I think you were telling me earlier when we were just having a chat that a marriage contract may not be enforceable if it doesn't, if the parties did not get independent legal advice.
And provide full financial
Both,
disclosure?
yes, yes. So it's not just a matter of getting a contract and having a witness and there you go. It's not that simple.
No. The one thing is, however, that if you're going to a reputable source, like for a template for doing a marriage contract or
Yeah.
cohabitation agreement,
Mm-hmm.
most of the good reputable ones that are out there now, they do like have a checklist of the different things that you should be thinking about, of what can and should or shouldn't be included in an agreement. So it's a good starting point.
Right.
And you and I had talked about like these kitchen table agreements, like if you just got a young couple sitting down on their own and they agree between themselves what they want to do, and they write up
Yeah.
this agreement and they get a witness and they get it signed, is it binding?
Yeah.
Probably not. But again, there are a lot of couples that will go through the time and the effort to do it properly, which means that they're going to provide full financial disclosure about what each of them has in the way of assets and debts going into the marriage. Then they have to talk about how they're going to handle their finances during the time of the marriage. And that's probably like the biggest cause of relationship breakdown in Canada is finances.
Mm-hmm.
And it's because people don't talk about it before they move in together or start actually living together as a family unit. Like they never think about saying, well, are we each going to keep our own separate bank accounts, and who's going to pay for what bills, and what happens if this piece of property that we have or that one of them has increases in value during the marriage? Is it something that we should both share in or only one?
Yeah.
But it makes you think about a lot of things that you should be thinking about in any event. So again, using a reputable template gives you the ability to sit down and get a pretty good idea of the lay of the land. You can get everything together to do your own financial disclosure as well. And then at that point, you're really well prepared to go in and see a lawyer, so that the cost of getting an agreement done properly that will be right for you and binding in the event the relationship breaks down is going to be a lot more probable if you do your homework first.
So of course you would advise against the couple hiring the same lawyer?
They can't. Well, the lawyer should be telling them you can't do it, because that's why you call it independent legal advice. Because if you retain me to review a cohabitation agreement on your behalf, my requirement under my obligations to the Law Society is to protect your interests and to
Right.
give you the best advice possible for what you should be doing. And you and the other side are not, you don't have, you've got conflicting interests.
But
You want,
usually what happens is one of the partners, they go and hire a lawyer, and the lawyer provides them a draft. So I suppose like I'm just wondering about the practical side of things.
well, that's altogether quite possible. It'll be one side, usually the one that really, really wants the agreement.
Right.
Again, there should be the discussion first between the parties, so they can at least start roughing out
Right.
where they think they want the agreement to go and what it's going to say.
Right.
And then the one that really wants the agreement will generally be the one that goes out, hires a lawyer who
Right.
will draft the agreement based on the instructions they receive from their client.
Right.
But then what they will do is send the draft to the other party with a letter confirming that that other party should be obtaining independent legal advice to review
Okay.
the agreement. And then both parties would have there's actually a certificate that's generally included on the agreement where both parties are acknowledging they've had independent legal advice. Or at the very least, that there will be an acknowledgement, like let's say that one party does get the agreement prepared, send it to the other party just absolutely refuses to get independent legal advice, there will be an acknowledgement that that person has to sign saying, I have been advised that I should be seeking my own independent legal advice. I am aware that I have been advised of this, and I am specifically saying I am choosing not to obtain independent legal advice, and that this is a decision that has not been made under duress, blah, 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 blah. It's pretty standard wording. So then later on, that person can't turn around and say, well, I had no idea. If I had had a lawyer tell me that I was entitled to X, Y, Z that I didn't even know about, I would have never signed this agreement. Then they can be held to that release and acknowledgement that they've been advised to get independent legal advice and they failed to do so. On the other hand, I would be very, very reluctant as the lawyer that acted for the person that wanted the agreement done up, to allow that person to enter an agreement where the other side does not get independent legal advice. Sometimes it can be a financial issue because, again, there's generally more than just the review of the agreement because, like I said, there's that requirement for financial disclosure. And if you're getting your lawyer to help you to make sure you've got the appropriate financial disclosure for you and also reviewing the financial disclosure from the other side, there could be those kind of additional costs. If you've got somebody with a lot of money, it's not that unusual for the person that actually retains counsel to do that agreement that they will say, I will cover your legal fees to the other side for getting independent legal advice. But they're not pulling any strings on the other party or anything else. It's still just saying, okay, I know you're saying you can't afford this. You need to get independent legal advice. You pick a lawyer. It's a lawyer of your choice. You do it. And it's just, I will give you the money to pay the lawyer. So you're not paying for it out of your pocket.
Yeah, that sounds very reasonable. It makes a lot of sense. Wow, that.
And we've been talking about, now again, I said we'd break it into two. Like you can enter into the same kind of agreement if you're going into a cohabitation relationship as well.
Right.
It's not as common, but again, it could be because there's generally not as much need for it because going into a common law relationship, you're going in that if you separate down the road, you've got no property rights that are set out in legislation that you might want to tweak and vary and deal with things in a different way than what's set out in the legislation because there is no legislation. But again, even for a couple that's looking at moving in together, it doesn't hurt to have them sit down and say, so what's our life going to be like on a day-to-day basis? Who's going to pay for the heat? Who's going to pay for the hydro? One party makes 3 times as much as the other party. If we decide to buy a house together, how is that going to work? If I can't pay anything towards a down payment, are we going to agree that I get some value in the house so you don't have to bring a claim for a constructive or resulting trust or whatever because I'm not on title? Or do you agree right off the bat the house is going to go in both names and we're both, which means we're acknowledging right from the beginning this is our house 50-50.
Yeah, no, those are really, really good points because I think that sometimes I think young people especially, they're not even aware that they should be talking about these things.
Oh, money. Like I said, it's the biggest cause of relationship breakdown and probably the thing that people talk about the least before they get married.
Yeah, but these are excellent recommendations. So do you have any final tips and suggestions that you want to say to our viewers today?
Well, just basically the final recap is don't assume just because you've lived together for 15 years that you're entitled to everything that you would have gotten if you'd have been married instead of just living together. It doesn't work that way. If you are separating, redo your will or at least revoke any of your existing wills as soon as you can. That's always something, whether you're in a common law situation or a marriage situation, you should really be doing that. If there are children or if there is property, do what you can to see if you can negotiate an agreement that is fair to both sides. If one party is trying to take advantage of the other, the courts are not going to look at it kindly if it ever does go into litigation. So again, that's why marriage contracts or cohabitation agreements are a good idea. Like, work out what's going to happen in the event that the relationships break down while you still like each other. So you want to be fair to each other.
Wow. Okay, so that was a lot of information today to digest, but Amazing. So you're like a walking encyclopedia. Well, thank you so much, and thank you everyone for watching. If you're new to our channel, don't forget to hit the subscribe button so you'll be notified of our upcoming videos. I will be adding more videos to the series because I think, Helena, you just mentioned the part about the wills, which is really important. So I'm going to be speaking with another lawyer soon to do a video on that. And yeah, so I want to thank everyone again for being here today, and we'll see you at the next time. Bye.
Great. Thanks, Heather. Bye-bye.